The Federal High Court in Abuja has stopped the federal government's planned arraignment of Justice Onnoghen before the Code of Conduct Tribunal. In his ruling on two separate ex parte applications seeking to stop the trial, Justice Edward Maha ordered the parties to maintain status quo to January the 17th. He ruled on the two different suits that the defendants should be served with all the party papers filed and appear in court at the next hearing. One of the two suits was filed by incorporated trustees of the Center for Justice and Peace Initiative. The other was filed by the incorporated trustees of the International Association of Students, Economists and Management. Those joined as defendants in the suit include the Attorney General of the Federation and Minister of Justice, the Chairman of the CCT, the National Judicial Council, the Inspector General of Police, and the Senate President, Dr. Bukola Saraki. Now, the planned arraignment of the Chief Justice of Nigeria, Justice Walter Onnoghen, failed to hold today at the Code of Conduct Tribunal. Justice Onnoghen, who is facing legal action on 6 counts bordering on alleged failure to declare his assets, was absent in court. Proceedings against the Chief Justice have been adjourned to Tuesday, January the 22nd, 2019, after both the defense and prosecution counsel present their arguments. Our correspondent, Kayla Megwa, reports.
It was a massive show of solidarity as 43 senior advocates of Nigeria, assisted by 47 other lawyers, showed up at the Code of Conduct Tribunal to represent the Chief Justice of Nigeria, who is facing charges of non-declaration of assets. Although the Chief Justice was absent, the lead prosecutor, Aliyu Umar, told the tribunal that the CJN directed his personal assistant to receive the charge on his behalf. This submission was challenged by the defense team led by Mr. Wole Olanikpekun, who argued that criminal charges are to be served directly on a defendant. He also informs the tribunal of his preliminary objection, challenging the jurisdiction of the tribunal to entertain the case. After listening to arguments from both parties, the chairman of the tribunal directed that the Chief Justice be served personally and adjourned the case till Tuesday, the 22nd of January, for arraignment and hearing of the preliminary objection. With a new date fixed for the arraignment, the prosecutor defends the action on the ground that all men are equal before the law.
There was an indirect protest that the defendant was not served personally. What the registry said was that we went to serve him, and he now directed that we give his PA the papers. In law, because it was not personal, that is no service. So that's why the tribunal decided that he should be served personally again, with the instructions to the staff that they should not give it to any other person except him.
The defense team declined making any comments on the matter. The Chief Justice of Nigeria is to be arraigned before the Code of Conduct Tribunal on a 6-count charge bordering on alleged non-declaration of assets. But next week, Tuesday, we'll be looking at where the case is going and if this court has the jurisdiction to hear this matter. Kayla Megwa, Channels Television News.
Meanwhile, the PDP Presidential Campaign Organization has accused President Muhammadu Buhari and the APC of what it describes as desperation in the assault against the judiciary with the alleged attempts to forcefully remove the CJN. In a statement, the PDP spokesperson, Mr. Kola Ologbondiyan, says the APC and the presidency are attempting to blackmail Nigerians who have condemned the move as being sympathetic to corruption. According to the statement, quote, the Buhari presidency and the APC in this venture have exposed their desperation to subdue and annex the judiciary, particularly following increased agitation by Nigerians for the prosecution of President Buhari's cronies and the APC leaders over exposed corruption, end of quote. The PDP alleges that apart from failing in all its promises, the APC and its presidential candidates are beginning to manifest their autocratic attributes as well as encouraging corruption. Mr. Ologbondiyan challenges the APC to name one of its members that's been investigated, prosecuted or arraigned before any court of competent jurisdiction in the last 3.5 years over corruption. Now, while all this rages on, the All Progressives Congress insists that the planned trial of the Chief Justice of Nigeria before the Code of Conduct Tribunal is a legal matter and the law must be allowed to run its course. According to the ruling party, Justice Walter Onnoghen must go through the court processes as an institution he represents. Now, this is contained in a statement from the National Publicity Secretary of the APC, Mr. Lanre Issa Oniru. The APC spokesperson accused the opposition People's Democratic Party of interference and politicizing the issue. He says, quote, "We have also noticed the very dangerous attempt to designate the CJN's arraignment along ethnic and religious lines, thereby trying to heat up the polity by evoking primordial sentiments which could do the country no good. This is an ungodly ploy when we consider that the CJN was an officer of the Federation rather than that of any region," end of quote. The statement also condemns the call by the PDP South-South governors for the CJN to boycott the CCT trial, adding that nobody, no matter how highly placed, should be above the laws of the land. All right, let's get another perspective from these issues now. I'm being joined on the news at 10 by Professor of International Law and Jurisprudence, Professor Akin Oyebode. Thanks a lot for joining us on the news at 10, Professor.
You're most welcome.
To try or not to try, I think that's the way they say it in literature. So many of your learned colleagues have weighed in on this issue, what should have happened, and there have been various interpretations. How grave is this, do you think, for the judiciary?
Well, it's a trial that has consequences for the judiciary. I'm reminded here of the statement by Juvenal in ancient Rome, "Quis custodet ipso custodies," who will guard the guards themselves. Now, the courts or the judiciary, the judges, are the sentinels of the liberties and rights of ordinary citizens, but that does not imply that they are above the law. One of the most respected judges in England, Lord Denning, in the celebrated case of Gurrier and Union of Postal Workers, opined, citing Thomas Fuller, "Be you ever so high, yet the law is above you." So judges are not immune, but then the prosecutor must ensure strict compliance with due process.
And that was where I'm going, because I'm not going to quote section 292 because it's out there and it's been quoted severally in the last couple of days. But people are screaming due process, especially lawyers. In your opinion, did the CCB err by not bringing him before the NJC first and doing it this manner?
Well, I think the prosecution ought to have followed the extant law in the country, that when an allegation involves a sitting judicial officer, then the matter should be remitted to the National Judicial Council. And if the NJC finds prima facie evidence of malfeasance or misconduct, then of course such a judge should be removed from the judiciary, so that you don't do an overkill, in my view. Since that was not done, it's a problem, but a problem that is not without solution. So the needful could be done for the matter to be properly brought before the Code of Conduct Tribunal. But I hasten to say that trying judges it's not a novelty peculiar to Nigeria. The Kenyan Deputy Chief Justice is being arraigned for corruption, tax evasion, and what have you. And in the recent past, judges not too far from here in Ghana had been removed from the judiciary on allegations of corrupt practices. So what is happening really is not unprecedented. The only thing that makes it remarkable is that we are dealing with the Chief Justice of the Federation, the highest judicial officer in the land. So I will respectfully submit that the Chief Justice should not listen to those who are saying disobey. It's not the practice of lawyers to disobey. And the Chief Justice is a lawyer first and foremost. That is why you find a whole crowd of senior advocates and lesser placed lawyers who decided to announce their appearance to defend the Chief Justice of Nigeria.
You think they shouldn't have gone in such a number? Or?
Well, again, you can't stop people from exercising interest in such a matter because lawyers tend to see courts as their marketplace. And they will imagine that any disparaging of the judicial officers, as we had last year, not to talk of the Chief Justice of Nigeria himself, could be a disservice to the entire legal profession.
Okay, Prof, the way you see it, can the CJN carry on, you know, overseeing the affairs of the judiciary, even looking at perhaps his more immediate task of if any party decides to go to the Election Petitions Tribunal, with the way it is, whether he is in court or he isn't in court, what do you suggest?
Well, you know, you can't bring a judicial officer who has not been separated from the judiciary before another forum, before another court. I think wisdom would suggest that the Chief Justice of Nigeria should disqualify himself from further participation in legal processes. Well, he cannot remove himself except he resigns. The procedure for removal of the CJ is well known in terms of the Senate advising the President. So once we did not comply strictly with the extant law, then that gives ground for suspecting that maybe there's a hidden agenda.
On that note, I was going to ask whether all the talk about is this political, the timing is suspicious. Quickly now, what you think about that on this talk of agenda?
Well, I would say all of the above, because it's a precarious situation and perilous circumstances that we are living through in the country. In another couple of weeks, we're going to have the presidential elections. And of course, ultimately, if there are any disputes, the matter will end up in the Supreme Court. So it's very difficult to separate politics from what is going on. But then, if you ask me, I would say that Honorable Justice Onnoghen had almost admitted violation because it's not been arraigned. It's not asked to make a plea. But my information is that he pleaded or said that it was out of inadvertence. Now, as far as I know, amnesia or loss of memory is not a ground, you know, for quashing any proceedings.
All right, Prof, on that note, I'm going to have to leave it. Professor of International Law, Professor Akin Oyebode, thanks for sharing your thoughts and breaking that down for us on the news at 10 tonight.